Ladies and gentlemen, thank you for standing by. Welcome to the Dorsey and Whitney's webinar on implications of the U.S. Supreme Court's Inclusive Communities decision regarding disparate impact litigation. During the presentation, all participants will be in a listen-only mode. If at any time during the conference you need to reach an operator, please press *0. As a reminder, this conference is being recorded Thursday, August 27, 2015. I would now like to turn the conference over to David Scheffel, partner at Dorsey & Whitney. Please go ahead.
Thank you. Welcome, everyone. Thank you for joining us. Today we'll be discussing the impact of the United States Supreme Court's recent decision in Texas Department of Housing and Community Affairs versus Inclusive Communities. My name is David Scheffel, and I'll be moderating the program. Before I introduce the speakers, I wanted to mention that our group, the Consumer Financial Services Practice Group, has established a blog. On a weekly basis, we are publishing truly substantive articles that address many of the hot issues in the CFS industry. The blog can be found at consumerfinancialserviceslaw.us, which is on slide 1. If you have a moment, please take a look at it. Let me introduce our speakers for today's presentation. First, we have Joe Lynyak, who is based in our D.C. and Southern California offices. Joe has been a bank regulatory attorney for over 30 years. He has significant experience in the mortgage field in general and significant experience in the housing discrimination context in particular. Joe is also co-chair of Dorsey's Consumer Financial Services Practice Group. Next, we have Eric Epstein, who is based in our New York office. Eric is also a member of our Consumer Financial Services Practice Group. Likewise, Eric has significant experience in the CFS field. Notably, Eric has litigated discrimination cases involving the Fair Housing Act, including ones involving disparate impact. And finally, we have Nick Vlietstra, who is based in our Minneapolis office. Nick advises and represents financial service industry clients on a wide range of consumer legal and regulatory issues and has published several articles, including most recently one analyzing inclusive communities. Before I turn it over to our speakers, let me first set the stage for today's presentation and then set forth the topics that we'll address. In June 2015, the Supreme Court issued its decision in inclusive communities. In a 5-4 decision, the court held that disparate impact discrimination claims are cognizable under the Fair Housing Act. However, the court included a number of cautionary statements regarding abusive disparate impact claims and made clear that lower courts have a duty and obligation to assess the viability of a disparate impact claim and dismiss those claims that don't measure up to this viable standard. Inclusive communities is a landmark decision. It will significantly change disparate impact litigation under the Fair Housing Act. For example, the argument that disparate impact claims categorically lack a statutory basis is no longer viable. However, the decision, without a doubt, raises the bar for disparate impact claims and requires lower courts to assess these claims at an early stage. In this program, we'll address 4 topics. First, we'll explain the reasoning and rationale behind the Supreme Court's decision in inclusive communities. Second, we'll discuss recent applications of the court's reasoning. Third, we'll discuss recent regulatory developments related to inclusive communities. And finally, we'll highlight unresolved issues and key practical implications that arise out of this decision. Let me now turn it over to Joe to provide us a history and overview of disparate impact discrimination.
Oh, thank you, Dave, and good morning and good afternoon, everyone. I'm going to talk a little bit about the history and overview of disparate impact, which, as many of you know who are in the mortgage industry, radically changed several years ago when HMDA expanded its data points that we're reporting, and for the first time there was a sufficient amount of data to be able to go after the mortgage industry, which is always the key here, data to be able to prove disparate impact. And what it is, it's an evidentiary means by which a plaintiff can prove discrimination. It's a so-called effects test, and the effects test goes back to several cases, Griggs versus Duke Power Company and Albemarle Paper versus Moody, which arose under Title VII of the Civil Rights Act, which became the Equal Employment Opportunity Act. It's different from alleging intentional discrimination. In an intentional discrimination case, evidence is submitted to prove a specific intent to discriminate against a protected class. But in a disparate impact case, evidence of intentional conduct, evidence of intentional discrimination, is not available, and the actions of the defendant are arguably neutral in application. And so what you use is data, and statistically significant data may be used to show that the actions of the defendant has a disproportionate adverse effect on a protected class. And while the discrimination laws in the United States slightly vary, we're talking about discriminating based upon race, color, religion, national origin, sex, marital status, or age. And while disparate impact theory has always permitted a defendant to defend by showing that its actions have a legitimate justification, what is a legitimate justification has got to be viewed in quotes and is often the battleground for litigation or regulatory enforcement. And as an admonition in terms of going forward today, I think it's worthwhile to note that language here really does count, both in terms of interpretation as well as what our litigators are going to talk about in terms of burden shifting. Next slide, please. Prior to Inclusive Communities' decision, the Supreme Court held that disparate impact claims are legally cognizable under federal statutes concerning employment discrimination. Under the Fair Housing Act and the Equal Credit Opportunity Act, virtually all courts have held that disparate impact was likewise available to prove a claim. And for decades, Regulation B, implementing the ECOA, provided that the effects test was available to prove an ECOA violation. And for many of you who are as antiquated as I am, in Regulation B, there was always a footnote that talked about the effects test and availability in reference to the Griggs decision. But when the CFPB took over jurisdiction for the ECOA, they put it up into the body of the of Regulation B, thereby theoretically enforcing the legitimacy of the effects test. And that can be found in section Regulation B 1002.6A. Also, the other federal regulators jumped in. HUD issued an interpretive rule that stated clearly that disparate impact was a viable theory under the Fair Housing Act, and they went to great pains and came out with a very extensive, detailed description of what was necessary, the burden shifting, which again we're going to be getting into. And the CFPB and the federal banking regulators also confirmed in several other instances the validity of using disparate impact for ECOA and FHA cases, Fair Housing Act cases, the CFPB most notably on April 18th, 2012 in a press release. Next slide, please. As we mentioned, the language differences are important here, and this is where the battle came about in the Inclusive Communities case. In past several years, lenders aggressively promoted the legal position that while the employment discrimination laws specifically allowed for the use of disparate impact to prove a claim, the specific discrimination language in the Fair Housing Act and also the Equal Credit Opportunity Act was different and required a showing of intent to discriminate. In other words, it was narrower in scope. The legal argument was so strong, possibly because of the emergence of Justice Scalia, who likes to read things very, very carefully in terms of his opinions, that on several occasions both the Department of Justice and consumer advocacy groups successfully prevented this language, that is, the difference in language between Fair Housing Act, Equal Credit Opportunity Act, and the employment discrimination laws, from being considered by the Supreme Court. and in fact settled cases to avoid those cases going to the Supreme Court or being dismissed because they were moot. In inclusive communities, however, the court held, as Dave mentioned, that disparate impact claims are legally cognizable under the Fair Housing Act as well, but the court placed important limits on those claims, and whether or not those are going to be upheld as time goes on is really part of the $64,000 questions we're going to be considering today. Next slide, please. And of course, everyone's probably thinking, why does it matter? Well, it's going to change the way the disparate impact litigation is brought and defended under the Fair Housing Act and probably under the Equal Credit Opportunity Act. The idea that disparate impact claims no longer can be used, that is now moot. It is no longer a viable argument. However, the decision arguably raises the bar that such disparate impact claims call for defenses to be available to defendants allegedly engaged in discriminatory behavior, and we're going to see whether or not that is going to be the case. I am actually one of the pessimists here in that I think it is likely that inclusive communities will be relied upon by the lower courts to permit the continued use of disparate impact brought under the ECOA, but time will tell as it works its way through the courts. Having given this overview, let's turn it over to Eric, and he's going to talk about the case itself. Eric?
Thanks, Joe. I'll now begin to review in greater detail the factual and procedural background of the inclusive communities litigation. While this background was not the focus of the Supreme Court's opinion, it likely will be in the spotlight now that the case has been returned to the district court on remand. In fact, the district court's decisions going forward on remand may send an important early signal regarding whether or in what respects the Supreme Court's opinion really can change the equation in a disparate impact case. The inclusive communities case concerned a provision of the Internal Revenue Code, 28 U.S.C. 42, that by its terms is not about race or ethnicity. This provision of the code, entitled Low Income Housing Tax Credit, permits businesses to claim a credit for the construction of low-income housing. The defendant in the inclusive communities case is the agency responsible for administering these credits in the state of Texas. The plaintiff in the case, the Inclusive Communities Project, or ICP, assists low-income African-American families with finding affordable housing in suburban communities. ICP claimed that by incentivizing the construction of affordable housing in low-income communities, the defendant was perpetuating patterns of racial segregation in violation of the Fair Housing Act. Notably, another NGO, Fraser Revitalization, also intervened in the case, but on behalf of the defendant and in opposition to ICP's claims. Fraser's mission concerns the revitalization of low-income areas of Dallas. And accordingly, Fraser argued that the defendant's policies were helping such areas and that the relief sought by ICP would be harmful and indeed unlawful. Ultimately, the district court conducted a bench trial, and the court first considered and dismissed ICP's claims of intentional discrimination. In fact, the court found that the defendant's intent was to prevent or mitigate any disparate impact. Specifically, the defendant had voluntarily instituted a policy of supporting low-income housing in affluent neighborhoods. ICP's disparate impact claim was that this policy, while laudable, did not go far enough. The court held that the defendant's good intentions were not a defense as a matter of law to this disparate impact claim, and in connection with the disparate impact claim found in ICP's favor. The court noted that credits were granted more often by the defendant in minority-majority areas. The court indicated that the racial component of this issue was related to the correlation between income and race in the state of Texas, rather than specific policy choices by the defendant. But the court did not find this point to be legally relevant. In addition, the court did not concur with Frazier's position that these credits were helpful to such communities. From there, the court posed the question, has the defendant proven that it could not have gone further to combat the problem of segregation in housing? The court answered this question in the negative, and on that basis, the court found in ICP's favor on the disparate impact claim. And beyond that, awarded ICP close to $2 million in attorney's fees and issued a detailed remedial order. Two distinct issues have been heard on appeal. First, the Fifth Circuit Court of Appeals found that the district court erred by placing the burden on the defendant as opposed to ICP regarding the question of whether the defendant should have employed different policies with respect to the allocation of credits and the mitigation of a disparate impact. Second, the Supreme Court, in addition to concurring with the Fifth Circuit on this issue, also considered the more fundamental question of whether disparate impact claims are cognizable under the FHA. Next slide, please. Over the next several slides, I will discuss the Supreme Court's reasoning in greater depth. The court's decision involved a statutory analysis of the language of the FHA. As a starting point in that regard, it is notable that the FHA does not actually contain the phrase disparate impact, notwithstanding that this phrase has been in common usage. From there, the question that the court faced was whether the absence of that language from the FHA meant that disparate impact liability was excluded, or whether it was possible to find that disparate impact liability was implied. The majority of the court took the latter view, finding that a statute may imply disparate impact liability without explicitly using the phrase disparate impact. Next slide, please. Specifically, the court held that disparate impact liability is implied in the Fair Housing Act for 4 separate reasons. First, Section 804A of the FHA refers to actions that, quote, make housing unavailable, which the court construed as a provision that was focused on consequences rather than a defendant's intent. Second, Section 805A of the FHA similarly refers to discrimination in making housing opportunities, quote, available. Third, the court focused on the 1988 amendments to the FHA. The court found that with these amendments, Congress could have explicitly rejected disparate impact theory, but did not do so, thus implicitly adopting it. Lastly, the court held that disparate impact liability could serve the statutory purpose of combating discrimination. Next slide, please. The court's holding that disparate impact claims are cognizable under the FHA, in a sense, does not change the legal status quo, in that previously every court of appeal to address the issue had reached the same conclusion. But the opinion nonetheless may change the nature of disparate impact litigation because of the court's commentary on the dangers of such litigation and the court's guidance to lower courts in that regard. Specifically, first, as noted in the Supreme Court's opinion, lower courts now must promptly assess the viability of a disparate impact claim. Second, because disparate impact litigation should not be about the imposition of, in the court's words, racial quotas, a plaintiff cannot state a disparate impact claim merely by pointing to a statistical disparity. Instead, a plaintiff, among other things, must show that such an alleged disparity is grounded in voluntary policy choices on the part of the defendant. By contrast, if such a disparity is a product of factors outside of a defendant's control, such as baseline demographics or the defendant's other obligations under federal law, then a plaintiff's case cannot succeed. Next slide, please. Even if a plaintiff states such a prima facie disparate impact case, the defendant, under the Supreme Court's guidance, still can prevail by showing that the policy or practice at issue was, quote, necessary to achieve a valid interest. In addition, a valid interest may include, Supreme Court held, practical business choices and profit-related decisions. This language is important because it confirms that this defense can be invoked by businesses and that disparate impact litigation should not become a vehicle for making value judgments regarding different lawful business interests. At this point, the burden of persuasion will shift back to the plaintiff, who can only prevail by showing that the defendant could have served the same valid interest in a less discriminatory fashion, as the Fifth Circuit previously had held. Two issues, one procedural and the other substantive, likely will soon come to the forefront as lower courts seek to apply this guidance of the Supreme Court. Procedurally, one important question will be, when will lower courts test the sufficiency of a disparate impact case? And in particular, what will be required of a plaintiff at the pleading stage of a case, and what will be deferred for summary judgment or trial? Arguably, given that many disparate impact cases are built, as Joe noted, on publicly available data, the failure of a plaintiff to state a disparate impact claim rigorously in an initial complaint should not be excused. Substantively, an important question will be whether and in what respects, on a motion to dismiss or motion for summary judgment, courts will bring to bear principles from the field of statistical science to rigorously assess the validity of a disparate impact claim, or whether courts will tend to defer to the parties' experts and let a jury sort out that pool of experts at trial. For example, will we see courts employing certain benchmarks of statistical significance? Will courts engage with questions such as whether a plaintiff has identified a proper control group, or whether a plaintiff has used relevant, reliable data? To the extent that courts are reluctant to wade into these areas, the helpful language in the inclusive community's decision may mean that much less as a practical matter. Next slide, please. I will now touch on two recent cases that have applied the Supreme Court's guidance. The first, City of Los Angeles v. Wells Fargo, is a useful precedent for defendants in the housing industry because the district court, citing the Supreme Court's decision, granted Wells Fargo's motion for summary judgment and dismissed a disparate impact claim. In the Wells Fargo case, the City of Los Angeles asserted that two categories of Wells Fargo loans had a disparate impact on minority borrowers. The first was what the plaintiff characterized as high-cost loans, meaning loans with a higher rate spread. The court dismissed this aspect of the city's case for two reasons. First, the failure to show a statistically significant difference regarding the probability that a Caucasian or minority borrower would receive such a loan. And second, the failure to identify a relevant Wells Fargo policy as to high-cost loans. In particular, the court determined that what the plaintiff really wanted was for Wells Fargo to create a policy limiting the origination of such loans to minority borrowers, which in the court's view would have constituted an improper racial quota in accordance with the reasoning of inclusive communities. Next slide, please. The second category of loans at issue in the Wells Fargo case were loans guaranteed by the Fair Housing Administration. The plaintiff characterized these loans as harmful to minority borrowers, given that such loans in some instances could be more expensive than conventional loans. The court found that this argument also could not pass muster under inclusive communities, given that such loans represented an extension of federal policy. As the court held, if any disparate impact results from FHA loans, it is a result of federal policy and not Wells Fargo policy. Next slide, please. To date, the other important case applying the Supreme Court's guidance is Abril Rivera v. Johnson, a First Circuit Court of Appeals decision. Here, the court affirmed the summary judgment dismissal of a Title VII disparate impact claim. In this case, a group of FEMA employees in Puerto Rico asserted that the closure of a FEMA facility at which they were employed had the effect of discriminating against them on the basis of their Puerto Rican heritage. The court dismissed this disparate impact claim for two reasons. First, the court held that Title VII does not permit disparate impact claims relating to alleged discrimination on the basis of the location or geography of an employee. This aspect of the court's holding is important because it suggests that even in the wake of the inclusive communities decision, disparate impact liability will not automatically be inferred into every federal anti-discrimination statute. Second, the court held that in accordance with the burden-shifting framework set forth in inclusive communities, the government had identified legitimate business justifications for the closure of the facility. This element of the decision is also an important precedent in that it indicates that while the inclusive communities decision came about in the FHA context, the court's guidance and cautionary statements as to the dangers of disparate impact claims may also be applicable to other disparate impact regimes.
Thank you, Eric. So at this time, I'm going to turn it over to Nick, who is going to discuss certain recent regulatory developments. Nick.
Thanks, David. As David just mentioned, I'm going to discuss inclusive communities in relation to some recent regulatory developments. The first I'm going to touch on is a rule that's already been mentioned in this presentation, was mentioned by Joe during his earlier slides, and that's HUD's rule implementing the Fair Housing Act's discriminatory effects standard. It's not only potentially affected by the ruling, but it's also relevant to the procedural history of the case and is even discussed specifically in the Supreme Court decision. As has been mentioned already, while the case was on appeal to the Fifth Circuit, HUD promulgated this rule that addresses disparate impact liability under the Fair Housing Act, and it provides a burden-shifting framework for disparate impact litigation. Under that HUD rule, once a plaintiff makes a prima facie disparate impact claim, the defendant has the burden of proving that the challenged practice is necessary to achieve a substantial, legitimate, non-discriminatory interest. And I'm quoting the HUD language when I say substantial, legitimate, non-discriminatory interest. To the extent the Supreme Court's decision touched on the burden-shifting framework that governs disparate impact cases under the Fair Housing Act, the decision was, in some respects consistent with the HUD regulation, but in some other respects that I'm about to discuss, it employed language that differs from the HUD rule. The inclusive communities decision, the Supreme Court described the defendant's burden in different words than those that I just quoted. It said that the defendant's burden is to show that the underlying policy is necessary to achieve a valid interest. And the court noted, as has been mentioned, that practical business choices and profit-related decisions may constitute valid interests. And it said that the court must distinguish between artificial, arbitrary, and unnecessary barriers and reasonable policy choices. So the HUD language, substantial, legitimate, non-discriminatory interest, is arguably more plaintiff-friendly than the language of the inclusive communities decision, in that a valid interest appears to be a less demanding standard for a defendant to meet than a substantial interest. If valid interest can be interpreted to be a less demanding burden than the inclusive communities decision, it's helpful to defendants on this point. So as I say, the question raises whether this aspect of the decision has modified the HUD regulation in any meaningful way. In the court's opinion, the court points out that the HUD regulation does not appear to intentionally seek to raise the bar in this regard, and the HUD policy statement that accompanied the promulgation of its rule also notes that the phrase substantial interest is meant to be analogous to the Title VII requirement that an employer's interest in an employment practice with a disparate impact be job-related, essentially a business necessity standard. Nevertheless, if a court were to interpret the language of the test using the ordinary meaning of the words, the Supreme Court's phrase valid interest does seem to suggest a less onerous burden than what HUD appeared to have in mind when it promulgated its rule. And it remains to be seen exactly what standard HUD, the CFPB, and the banking agencies will use and what standard the courts will follow. But the lack of clarity on this issue might result in some inconsistent decisions in the future. Next slide, please. Another even more recent HUD rule of relevance to the inclusive communities decision is HUD's rule called Affirmatively Furthering Fair Housing Rule, and a link to that rule is there on slide 19. This rule was published in final form on July 8, 2015, so very recently, and it concerns implementation of the Fair Housing Act's requirement that jurisdictions receiving federal funding for housing and urban development have a duty to affirmatively further fair housing. And the rule imposes a number of additional duties on public housing agencies and other HUD program participants like state and local governments to more vigorously implement their affirmative fair housing obligations. And in particular, the new rule provides that HUD will provide each of the program participants with data covering the local jurisdiction and the surrounding region, and that the program participants must then consider this data when assessing the fair housing landscape in their area. And the data is going to include integrated and segregated living patterns, racially or ethnically concentrated areas of disproportionate housing needs based on classes protected by the FHA and a number of other data points. And it's intended that this data will allow the public housing authorities to evaluate fair housing issues such as segregation and disparities in access to housing. Now, interestingly, the rule goes well beyond requiring analysis of the data and statistical significance and really embodies a requirement also that the program participants analyze their fair housing landscape in a much more broader or holistic way to see how their local fair housing issues are going. It provides for program participants to supplement the data provided by HUD with available local information and to rely on other more subjective indicators, including there's a kind of a robust community participation and feedback requirement in there that in the form of soliciting public input and commentary on these issues. One issue of interest is during the notice and comment period on this proposed rule, when it was being proposed, which took place prior to the inclusive communities decision by the Supreme Court, some commentators had raised or criticized that it was inappropriate for HUD to essentially be going beyond targeting intentional discrimination with its proposed rule and essentially incorporating a disparate impact theory as the basis for its rule. They even went so far as pointing out that the language of the Fair Housing Act differs in material ways from other federal statutes that support disparate impact theories, as we've talked about already. So this was all to say that the Fair Housing Act does not prohibit practices that result in disparate impact if there's no discriminatory intent. Next slide, please. So not surprisingly, HUD's final rule cites the Inclusive Communities decision, stating that the Supreme Court recently ruled that the Fair Housing Act prohibits discrimination caused by policies or practices that have an unjustified disparate impact. So HUD obviously feels its incorporation of disparate impact into that new rule is vindicated. Perhaps more importantly, it will now be important to track what types of data HUD provides to program participants and what kind of information and knowledge are deemed by HUD to be relevant and reliable for purposes of fair housing analysis under their brand new rule. And that, of course, remains to be seen. Also, this data is to be made available to the public and to public agencies and other interested groups, and so will likely be subject to scrutiny. Next slide, please. Another pending regulatory development that's significant in the context of the impact of the Inclusive Communities decision is the forthcoming amendments to Regulation C, which were mandated in part and authorized in part by the Dodd-Frank Act. And you can see a link is on slide 21 to the proposed rule. As you know, Regulation C implements the Home Mortgage Disclosure Act, affectionately known as HMDA, which has required certain financial institutions to collect and report information about their mortgage loans and applications for mortgage loans for quite some time now. Under the proposed rule, however, these reporting requirements are going to be expanded in a number of ways. For one, the Dodd-Frank Act included HMDA amendments that expand the scope of the information to be reported by adding even more data points that need to be collected and reported. Two, the Dodd-Frank Act authorized the CFPB to add even more data points to this list. So in July of 2014, the CFPB did propose this rule, amending Regulation C to add data points, the ones laid out in the Dodd-Frank Act, but also these hosts of additional data items that the Bureau wants to collect in order to assist it with monitoring and analyzing what's going on in the mortgage market. And these include borrower's credit score, DTI ratio, and where applicable would be the reasons for denial of the application. These new requirements essentially double the number of data points that are going to be reported under HMDA. In addition, the proposed rule expands the types of mortgage loans that are going to be reported, now essentially requiring reporting on all mortgage loans secured by dwellings. It also, for the first time, has a uniform reporting threshold for depository and non-depository institutions. Both types of entities are going to report if they originate 25 covered loans in the prior calendar year or more. The comment period on this closed back in October of last year, and we've been waiting for the final rule this year. One of HMDA's primary purposes is identifying possible discriminatory lending patterns and enforcing anti-discrimination laws, and the CFPB believes that the new data is going to help them address information gaps to better identify possible discriminatory lending patterns and practices. So, disparate impact claims under the Fair Housing Act are often based on the type of data which is going to be collected under the anticipated new rule. Because the rule substantially increases the amount of data and the number of data points available for attempting to prove a fair lending claim based on disparate impact. And now that we have the Inclusive Communities decision, it's very probable that the use of disparate impact analysis and this HMDA data will really increase for the residential housing industry. Next slide, please. Now, in certain respects, the additional reporting requirements could benefit defendants in fighting off disparate impact cases. As mentioned on the slide here, with more data publicly available, courts might challenge plaintiffs to kind of up their game, so to speak, or on coming up with meaningful statistical support for their disparate impact claim at the pleading stage of the case. Also, courts might allow defendants to point to helpful publicly available data at the pleading stage in support of a motion to dismiss a disparate impact claim. In other words, the court might be able to take judicial notice of the data, even if it's not been cited by the plaintiff in its complaint. And I think we're going to be talking about this later. If there's a finding that discovery rule can be a basis for tolling the statute of limitations on a fair lending claim, the ongoing availability of the data to the public could be used to undercut the tolling argument. The next slide, please. In other respects, though, the reporting of all this additional HMDA data could be negative for defendants. Obviously, in disparate impact cases, the data will be analyzed and scrutinized by advocacy groups and the media and other interested parties. Plaintiffs will have the raw data they need to craft arguably statistically significant results indicating discriminatory lending behavior. And it'll be more difficult for lenders to argue that the data is too limited and is painting an incomplete picture of their lending practices. And all this is going to be unfolding against a backdrop in which the courts might still be struggling with interpretation of the burden-shifting approach that we've discussed, and the application of the necessary to achieve a valid interest standard from the Supreme Court decision. And of course, HUD and the CFPB and the federal banking agencies may be resistant to the Supreme Court's guidance in that case. Next slide, please. An additional recent regulatory development of interest and related to the issue of availability of borrower data and fair lending enforcement is the recent CFPB investigations of the indirect auto lending industry. For one thing, it is an example of how the CFPB may use data it has available to it to pursue disparate impact claims. But in the auto lending context, interestingly, borrowers do not report their race or ethnicity in connection with their loan, and this presents a challenge to the CFPB in determining whether discriminatory practices exist in that market. So the CFPB has used publicly available information to proxy for race and ethnicity using a probability analysis called Bayesian improved surname geocoding. The CFPB uses borrowers' surnames and places of residence in conjunction with Census Bureau data to come up with probabilities as to the borrower's race and ethnicity. They then use the race and national origin probabilities to estimate any disparities in dealer markup on the basis of race or national origin. Now, this proxy approach has been controversial, and it's been criticized by many in the financial services industry as being unreliable and unfair, but nevertheless, it's been a successful tool for the CFPB and the Department of Justice. And while this example involves disparate impact liability under the Equal Credit Opportunity Act, entities subject to the Fair Housing Act should be aware of this technique as well. Even when race and ethnicity information is not provided by borrowers, the federal agencies may attempt to assign a race or ethnicity probability to those borrowers. Next slide, please. Okay, slide 25 brings us to the discussion of unresolved issues coming out of the Inclusive Communities decision. The first we have here on slide 25 is what is the impact of the Community Reinvestment Act. The Community Reinvestment Act, as you know, is designed to make sure that banks serve all segments of the communities in which they're located, including low and moderate income neighborhoods, and it requires lenders to identify and offer credit services to those borrowers residing in the community where the lender operates and advertises. And offering credit products in an effort to satisfy CRA goals can lead to variations in policies and standards and product offerings that can give rise to statistical disparities. First, it's important to remember that CRA audits are often made available to the public and thus can be used in private civil litigation. But second, the decision might impact the viability of any allegation that a credit product that's had an unlawful disparate impact if it was offered pursuant to the lender's CRA obligation. Certainly the Inclusive Communities decision might make it more difficult to make an allegation in that context. The court warns against imposing liability based solely on a showing of statistical disparity, and it's held that an important aspect of the plaintiff's initial burden is to show that the statistical disparity was caused by a policy or practice of the defendant, and it gives lenders leeway to explain valid interests underlying their policy or practice in defense of those disparities. Also, recall the court emphasized that policies are not contrary to disparate impact requirement unless they are, and I'm quoting, artificial, arbitrary, and unnecessary barriers, end quote. So an apparent statistical disparity is if it's a consequence of the defendant's compliance with other federal laws or regulations independent of the Fair Housing Act, the case may be dismissed. So acknowledging that lenders should not be put in a double bind of liability, I think is helpful in this context. So offerings made pursuant to a lender's CRA obligations may benefit from these articulated standards in the inclusive communities decision, at least under the court's view. Whether that is the same as the view of regulators is perhaps still unclear. Thank you.
Thanks, Nick. The plaintiff's burden of proof is a critical issue in disparate impact litigation. In inclusive communities, the Supreme Court has made clear that lower courts must conduct a rigorous assessment of these claims at an early stage. However, it's unclear how courts will interpret and apply the standard of review for disparate impact claims at the pleading stage. On the one hand, as Nick mentioned, we have the HUD rule that addresses the standard of proof for a disparate impact claim. That rule, issued in 2013, establishes that once a plaintiff makes out a prima facie disparate impact claim, the defendant then has the burden of proving that the challenged practice is necessary to achieve one or more substantial, legitimate, non-discriminatory interests. This is a very high standard for a defendant to satisfy. However, in inclusive communities, the court emphasizes that disparate impact claims must be carefully scrutinized at an early stage, and therefore is, to a degree, inconsistent with the HUD rule. In that regard, while the HUD rule states that a defendant must demonstrate a, quote, substantial, legitimate, non-discriminatory interest, end quote, to defeat a prima facie disparate impact claim, inclusive communities makes clear that a defendant can defeat such a claim by showing that the underlying policy is, quote, necessary to achieve a valid interest, end quote. Having to show a valid interest is, I submit and believe, a less demanding standard than having to show a substantial interest, and one that many banks and developers should be able to satisfy. In the end, it remains to be seen exactly what standard federal district courts and United States courts of appeal will use and whether they will apply the level of scrutiny suggested by the court, or whether certain courts will simply give lip service to the Supreme Court's cautionary instructions and hold banks and developers to a higher standard of proof. No doubt this will be a major battleground in these cases. Let me now turn it over to Joe to discuss some unresolved issues.
Oh, thanks, Dave. As he was just mentioning, a huge issue here is the defendant's burden, and in inclusive communities, it's necessary to achieve a valid interest, such as profit motivation in being done in a non-discriminatory manner, with, according to HUD's version, substantial, legitimate, non-discriminatory interests of the respondent or the defendant. And when you take a look at the HUD rule, which Nick went over and which Dave just mentioned, there are several different stopping off points which, if adopted and are valid, will place a very, very significant burden on a defendant defending a disparate impact case, because according to HUD, the justification must be legally sufficient. And the legally sufficient justification exists where the challenge practice is necessary to achieve one or more substantial, legitimate, non-discriminatory interests of the defendant, and the interest could not be served by another practice as a less discriminatory effect. And again, a comparison has to be made between that and necessary to achieve a valid interest. HUD is ladling on additional factors that are necessary, and then you go to the burden of proof shifting process, is that after the plaintiff has raised the claim, the plaintiffs must prove that the challenge practice caused, but interestingly enough, or predictably will cause a discriminatory effect. So it may be something in the future which you can't tell about currently, but they add the ability to open the door of, we're concerned about this, someday this may cause a problem, at which point then the defendant has the burden of proving that the challenge practice is necessary to achieve one or more substantial, legitimate, non-discriminatory interests, and again, on top of it, it must be legally justified. So it really is potentially a significant distinction between the Supreme Court's view of the world and that of HUD. And this may ultimately come down to another Supreme Court case, which is commonly known as Chevron, where the Supreme Court and the courts will give significant deference to an administrative agency charged with interpreting a statute, whether or not HUD's interpretation, the CFPB's interpretation, and those of the banking agencies in terms of this ladling on of additional components, in terms of the burden shifting we're talking about today, will be successful or not. Next slide, please. Unresolved issues, whether or not the case we've been discussing today also applies to the ECOA, and as I mentioned before, I'm not in the viewpoint that this is going to work, but it's still going to be challenged. The ECOA, among other things, does not contain the phrase "otherwise make available or deny," similar to the FHA. There was simply not the same congressional history as was in the case of the FHA, and theoretically you could distinguish the congressional affirmation from that which was a fact relied upon by the Supreme Court, and so therefore it is certainly possible to argue that ECOA should be treated differently, that is intentional discrimination, not disparate impact. But I think the handwriting is on the wall that eventually there's going to be a growing number of courts following this decision, inclusive communities, that are going to validate the use of disparate impact in an ECOA case, which for many in the financial services industry outside of providing direct housing assistance is really one of the touchstones. David, over to you.
Thanks, Joe. The Fair Housing Act's 2-year statute of limitations has been and always will be an important defense to a disparate impact claim. And as happens in so many cases, plaintiffs argue that the discovery rule should apply and essentially toll this 2-year time period. Currently, the landscape is unsettled, to say the least. The first issue is whether the discovery rule even applies to the Fair Housing Act. No circuit court has squarely addressed this issue in the mortgage context. However, the Fifth Circuit has addressed whether the discovery rule applies to the Equal Credit Opportunities Act, and notably has concluded that the discovery rule does not apply to this statute. Federal district courts have taken inconsistent views, some concluding that the discovery rule applies to the Fair Housing Act, and others holding that it does not. If we assume that the discovery rule applies to the Fair Housing Act, the next question is how courts should apply the discovery rule. For example, will courts conclude that a party has discovered the discrimination claim when she or he speaks with a lawyer? This is the view that plaintiffs' lawyers will take. Or will courts find that a party has discovered the claim once HMDA data is made public, which in turn gives the public all the information that's needed in order to discover the alleged disparate impact? And to be blunt, it's the government, not-for-profit organizations, and private law firms who are the ones spearheading disparate impact litigation. It's not the average citizen. And to bring these claims against banks and lenders, these organizations rely primarily on HMDA data, which data points have expanded significantly over the years, as Nick has mentioned. And once these organizations think that they have a potential disparate impact claim, they search for potential plaintiffs and sign them up. So when we frame the issue in this context, there is a compelling argument that, assuming the discovery rule applies, then it should kick in once a lender's HMDA data is made available on the public domain. For if this is not the case, then the discovery rule would extend the 2-year statute of limitations indefinitely. And that's clearly not what Congress or the Supreme Court envisioned. Let me now turn it over to Joe with about 5 minutes to go.
Thank you, Dave. A couple of practical implications to think about depending upon your circumstance. For mortgage lenders and other lending entities, regulatory audits will clearly continue to focus on disparate impact. There's not going to be an opportunity to challenge within that context. I will say that the CFPB, from my perspective, has always been on a cabal. They believe that there is a cabal in terms of the financial services industry of consciously discriminating against protected groups, and the way they go about their examinations is totally despicable in terms of their emphasis on it. But they're going to continue to do that, and there's nothing we can do about that. We'll talk a moment about what you can do in order to anticipate that. In the case of litigation claims, we've talked at length about the burden shifting and interpretations and the Chevron issues, and those were going to resolve themselves as they worked their way through courts. In regard to claims brought by private litigants, it certainly eliminates the dismissal on the grounds that disparate impact is not a viable option. But what it does possibly present is there's an obligation of linking the statistically significant evidence of discrimination to a policy or procedure, which in some cases may be quite difficult, particularly if lenders are careful regarding the avoidance of discretionary pricing, which as a practical matter has been almost eliminated in all areas other than perhaps direct and indirect car lending, and even there are major changes that are taking place. Next slide, please. In the case of disparate impact issues arising in the context of a regulatory audit, I think what you've got to expect is that the decision is going to be ignored by the federal regulators. For anyone who has gone through this issue, if you're part of an investigation, the floor falls out from underneath you in terms of the data that is being used, and burden shifting rule really doesn't necessarily apply in this case. What you've got is an enormous burden on your part to be able to gather information. And I will also say that if, God forbid, you go over to the Department of Justice on an investigation, opposing a drawn-out DOJ action is generally very, very impractical. What you end up doing is, for the most part, settling the case as quickly as you can. But, however, I will say anticipatory use of statistical information is the only reasonable avenue to pursue. Next slide, please. What you need to do is you need to have ongoing focused fair lending self-assessments. You need to be aware of the fact that current theories on the part of the government of what constitutes proof of a disparate impact changes from month to month, year to year, with new folks coming on board, particularly economists who have got new theories. New data is going to be available. I will say how that should be distinguished between intentional discrimination claims, which have now resurfaced regarding redlining and reverse redlining. Training is extremely important, as well as keeping in mind best practices for dealing with the regulators when they come in for fair lending audits, having your people trained and having anticipatory data ready for their review. So there's a lot to be thinking about in terms of avoiding the dreaded investigation, and it really takes a lot of effort on the part of mortgage lenders to be ready for those things. Thank you.
Thanks, Joe. This concludes our presentation. To all the listeners who joined us today, thank you. If you have questions about our discussion today, please send us an email at dorseyu@dorsey.com, which is on slide 1 of the presentation. Or you can email any one of us directly and we'll respond right away. Thank you again.
Ladies and gentlemen, that does conclude the conference call for today. We thank you for your participation and ask that you please disconnect your line.